Good morning and good afternoon to our audience members. We welcome you to the second installment of the Primerio telephone Zoom conferences. We hope that everyone is safe and sound in their respective abodes or offices or homes. And we will dive right in. The virtual room remains open for latecomers to straggle a little late into our conference today. The topic is recent developments in African competition law. And I welcome our panelists. We have 5 excellent speakers today. The conference will last exactly 1 hour. There will be opportunities for questions from the audience, which I will moderate if we have time and if they fit from a subject matter point of view. And the format will be that I will introduce each panelist very briefly as they give their opening remarks, about 5 or 10 minutes, no more than that. And then after that, there will be an open virtual floor discussion among them. I would like to note that one of our panelists, the renowned professor at New York University School of Law, Professor Eleanor Fox, who has kindly joined us today and who will start this panel off, she has to leave at 1:15, so in about 45 minutes, in order to teach her class, also via Zoom. She has to move to her other adjoining room. Therefore, we will give her the floor right now, and then also the opportunity to ask some follow-up questions of the other panelists later on, so that she gets all her insightful points in before this ends. Professor Fox, Eleanor, let me call you Eleanor.
Yes.
Good morning to you. You're also on Eastern Time. Please give us your introduction of what you have observed and what your thoughts are on the developments on the continent and perhaps globally in terms of competition law.
Right, so thank you, Andreas, and welcome to everybody. I'm very happy to be part of this panel and program. So I thought that to open the program, I might give a really broad overview of what's happening in the world, that's pretty broad, in terms of antitrust and even some broader economic issues, both the developed world and the developing world. And I want to do that in 2 parts. One is before coronavirus, BCV, and the other is after coronavirus, because some things have changed. So to start with the state of the world before February or March, I would say this about antitrust trends, that it's generally antitrust as usual, but in the last number of years, we've seen an enormous amount of nationalism creeping into the antitrust, sometimes by the backhand and not very transparently, and other times pretty transparently. And there's been much conversation regarding, for example, both US and EU. In the EU, big mergers, and although big mergers that are anti-competitive are usually stopped or conditioned, but lately they've been giving rise to a conversation that goes something like this. This is Siemens Alstom, a conversation that goes something like this. China is breathing down our backs. We've got to be more competitive. We've got to bulk up our power. Maybe there should be a new industrial policy in antitrust. And Europe with the new commission is winking at that. I mean, considering it. So for mergers, I would say that is what is happening. For monopolies and dominance, the big things in the news are the big tech. This is still pre-virus. Big tech is very much in the news, with EU being a very strong enforcer and US doing a lot of investigation. We don't know where it will lead. And another big issue, but not US, it's Europe and the world, is very, very high prices, such as for drugs, excessive pricing. And then I would say for cartels, it's sort of business as usual. Everybody's trying to find the cartels and prohibit them. And then if we just shift to Africa and developing countries in general, over the last number of years, the big trends include the fact that for mergers, there's also a little more nationalism, and there's a lot more protectionism, and there's a lot more conditionality that doesn't always relate to making the market more competitive, but often relates to protecting the small and middle-sized firms in the jurisdiction. There's also been creeping into the enforcement more executive and ministerial initiatives, for example, on conditioning mergers, and conditioning mergers in a way that gives the left out people in the society a bigger stake. This, while for very good reasons, has made the law less predictable. There's been a movement on buyer power, more concern with buyer power, more concern with price discrimination. And in both of these areas, it's also for example, South Africa and Namibia, historically disadvantaged persons. The agencies are actually trying to do guidelines to make the enforcement more predictable, and we're still seeing how that pans out. There are two problems, this is still pre the virus, two big problems that are persistent and I think not addressed. And one is there's so many more cross-border cartels than are, I think, even observed. There's not enough effort to get outside a country and look at what is happening cross-border. And there's also a problem on big mergers that are virtually always let through and often with conditions. And this goes for the whole world. In my view, there ought to be more aggressiveness in stopping very big multinational anti-competitive mergers. So shifting now to post-virus, nationalism has come in a major way with a vengeance. Because of the virus and the conditions of the virus, US, EU, countries within EU have closed borders. The export market is dried up. The tourism market is dried up. The shift is extraordinary to whatever we can do by electronics, e-commerce, we do it by electronics, and the local retail is shutting down, meaning that while big tech had power, it's getting more power, especially in retail. Oil price wars between Russia and Saudi Arabia have caused the prices to go way down, and meanwhile oil demand is much less because people are staying home, and that's wreaking havoc in a number of African countries, for example, Nigeria, Angola. There are a number, or at least several of the African countries with very fragile democracies where there's great and much greater political instability. There's a huge amount of concern for food security and of course for access to medicines. So how has that affected enforcement? Well, on enforcement for monopolies, the whole big tech, aggressive against big tech conversation has really gotten much more low-key, except the staff that are doing the enforcement activity, they're still investigating. And for high prices, that has become a huge issue with efforts to try to contain price gouging all over the world in different countries by different means, sometimes through antitrust, sometimes through unfair competition, consumer protection, and even sometimes, like France has new price regulation to control the gouging. For collaborations, there's been a relaxation of antitrust as needed to get scarce goods and services, medical especially, made and delivered. So all of this has increased the threat to developing countries. I know my time's running out, so just like 1 minute to wrap up. It's increased the pressure. Their markets are closed. Where they were on a better economic track, they've actually been pushed backwards with great crises. And there's more of industrial policy and public interest and less concern for institutions and maybe, well, certainly less trust in antitrust and a concern for due processes on the competition enforcement side and a bigger divide economically between the developed and developing world. Thanks.
Thank you, Eleanor. I think that sets the stage very well, and with the nice wide angle lens for the remainder of our panel today, because you touched on a lot of not only different jurisdictions but different topics, really, including what you said just at the end before we transition to John Oxenham, which he can then pick up on the sort of dueling and often, unfortunately or fortunately, married concepts of industrial policy and competition policy, right? Which, especially in the developing world, are more often combined than in let's say the EU or the US. But as you said, in the post-COVID world, in the PCV, so to speak, we do see that even in Europe and in the US. So John, maybe that's a good segue for your presentation.
Yeah, thank you very much. And again, good morning, good afternoon to everyone, and welcome to our second of our teleseminars. I think Eleanor's introduction was obviously excellent and certainly did tee up what I wanted to discuss. And primarily my focus is going to look at the impact of some of these industrial policy initiatives, and more particularly the sort of interventionist role that our executive has played in relation to merger control over the last couple of years. And then to, I suppose, gauge whether or not our amendments to our competition legislation have actually addressed or assuaged some of the concerns in that regard, and trying to bring back some focus regarding the due process initiatives that Eleanor touched on as well. I think if we were to look at that, and I think everyone's very cognizant of the role of public interest in our merger control process, it's certainly one of the lodestars internationally, and a number of our transactions have obviously set up other jurisdictions internationally to consider public interest more forcefully in relation to their merger control processes. But if we cast our minds back and really look at the interventionist role that has been brought about, and is probably a very fixed and firm feature in our merger control landscape, we don't need to go further back than our Walmart decision. And in that, I think everyone's very conscious of what took place, a significant set of intervention by a number of ministries. But importantly, and I think this is where I sort of agree with Eleanor in a very strong manner, is that the court had set out what standards should be adhered to, what the test ultimately was in relation to assessing public interest, the impact on public interest from a particular transaction, and did so in a very, I suppose, objective manner. Now, what happens since then is probably the cause of concern from a practitioner perspective, and that's obviously what I'm speaking as in South Africa. And I say that not just from our jurisdiction's perspective, but also the role that South Africa has across the continent and amongst other emerging jurisdictions. And I think Eleanor's touched on what can likely happen in other jurisdictions and will likely happen in other jurisdictions. But if we just traverse a couple of the cases which occurred post-Walmart, I think that's where, to my mind, the rot almost set in. A number of very large international deals which acquired South African players, touching back on Eleanor's points about nationalism and potential protectionism issues. There was an Africa transaction in terms of which one of the conditions which were ultimately sought by the ministry went so far as to preclude a shift in their headquarters from South Africa to an Indian Ocean island. Now, whether or not that touches back to the Competition Appeal Court's test originally in Walmart, as whether or not there was a nexus to the transaction, is questionable. Moving on to the Coca-Cola transaction, which occurred sometime after that, and these are all pre-Amendment Act changes. And again, I'm also dealing with the pre-COVID or pre-pandemic period too, just to use that overview. But if we look at the Coca-Cola transaction, that deal languished for a significant period until ultimately conditions were struck with the ministry. Moving on to the AB InBev transaction, which I think a lot of people are very conscious of, a significant set of conditions were agreed to up front, and ultimately that deal was expedited through the clearance processes. Now, everyone is conscious, and I'm certainly a very big supporter of it, the efficacy of our agencies. I think we've got very robust adjudicative agencies, The Competition Appeal Court is highly regarded internationally. Our jurisprudence is very rich. But what effectively all of this did is it incentivized parties now to go and engage directly with the ministry in relation to conditions which should be imposed in relation to mergers, rather than have these thrashed out, so to speak, before the adjudicative agencies. So going back to Eleanor's point, I think prior to the Amendment Act, we were in a very deleterious position. Along came our amendments, and these were very much ministry-led amendments, significant set of amendments, not just to merger control, but other aspects of our legislation, one of which was to elevate the status of our public interest test and bring in new standards or criteria against which a merger should be assessed. Those included ownership issues and also the role of SMMEs or small, medium-sized enterprises, again, what Eleanor was touching on again in her introduction. All of these are very laudable and significantly required in a jurisdiction like ours. But what didn't come, and what I think was a serious omission, was the guidance which was required, or the standards against which a lot of these public interest criteria should be assessed, or the ability to quantify the impact of the public interest and these new criteria. And I think what was a serious omission in relation to this process is at least enabling parties to know the scope of what their required contribution should be in respect of a particular transaction. And importantly, and I think again from a practitioner perspective, why that was required is that would at least enable parties to assess in advance the likely costs or impact of that series of conditions would be on their transaction. So what also happened in relation to the Amendment Act, and these are changes which were occasioned, again, as I said, were ministry driven to a large extent, is greater interventionist rights on behalf of the executive. So it wasn't just in relation to the merger control process directly, but there's now a provision which enables foreign acquisitions to be scrutinized, and also over and above the interventionist rights which are given to our ministry, there's the ability of the ministry to appeal directly to the Competition Appeal Court in relation to competition tribunal matters. So what we've called in the past sort of 3 bites at the cherry in relation to certain transactions. If we cast forward and look at a recent transaction, and the most recent, I suppose, mega deal which has occurred over the last period has been PepsiCo's acquisition of Pioneer Foods. If we look at the fundamentals in relation to that transaction, have things really improved post our Amendment Act, and has the interventionist stratagems, which are very clear cut in relation to our ministry, ultimately resulted in a better outcome for our merger control processes. So in that transaction, I don't think there were significant competition concerns, and that was acknowledged. Nor in terms of an old assessment of our previous act, or so to speak, the pre-amendment condition, public interest criteria, were there real concerns. But again, in relation to an agreed set and negotiated set of conditions, significant conditions were imposed, public interest conditions were imposed on the Pepsi Pioneer deal. Those included a triple BE ownership plan. They included obligations in the entity to grow operations, which include 500 jobs, direct jobs, 2,500 indirect jobs, maintenance of certain sales and distribution agreements, and then the now synonymous set of the development fund requirements. So to conclude from my perspective, and I think a large frustration, and perhaps to tie back into the overarching comments from Eleanor by way of an introduction, there certainly has been a very clear interventionist strategy. Whether or not that interventionist strategy has resulted in a better outcome remains to be seen. But what is glaringly omitted, and I think is becoming a serious concern from a practitioner perspective, and doesn't bode well for other jurisdictions who seek to emulate what takes place in South Africa, is that the vast majority of this is not assessed, adjudicated, or thrashed out before the competition agencies. And where our concern comes in as practitioners is until there is a solid set of jurisprudence which is developed to enable parties to gather some insight into what the likely ramifications are of these interventionist strategies, people are going to be held at the behest of the ministry. And I don't think that makes for a good position. I don't doubt that the intent is clear and certainly falls within the broader rubric of the Act. But from our perspective as practitioners, I think this is going to be a serious bone of contention, because it will never be clear as to when the big impact will come, what transactions it will come on, and what the ultimate obligations are going to be in relation to parties. So that's the pre-COVID world, and hopefully I'll get a chance to discuss the post-COVID world.
You will. Thank you, John. And I think it's indeed important what you raised at the end there, that South Africa is one of the most developed, both from a historical as well as, I think, activity perspective, one of the most developed competition law jurisdictions on the African continent, is being emulated by many other jurisdictions, as you point out. And that those jurisdictions that are more newcomer jurisdictions to antitrust are trying to copy that. And if it is not a good step in the right direction, then perhaps we do risk, or they do risk, falling into the same pitfalls. We will see, now that we discussed this in our pre-panel prep, we will see how the competition in the airline sector will fare now that SAA is about to go out of business. It'll be very interesting in a post-COVID world, and I want to hear your opinion on that later. For the next three panelists, I want to go geographically, and I want to make my way north. So we went from New York with Eleanor to Johannesburg with John, and I want to go via Botswana to Kenya, and then ultimately end with the sort of multi-jurisdictional pièce de résistance with Mike Currie, who will discuss a bigger picture, and also COMESA. So Chabo Peo, our colleague from Botswana, there has been an amendment that only went into effect effectively in late 2019, I believe, in your country. Can you give us an update on that?
Thank you, Andreas. Afternoon, everyone, and good morning. So similar to South Africa, our Competition Act was amended in 2019, and the similarity of South Africa is that the amendments were led by the Ministry of Investment and Trade. So what we've seen as well is we've seen an elevation of protectionism, as Eleanor mentioned, and also an elevation of citizen economic empowerment. Pre-December 2019, our authority was pretty
Did we lose Chabo, or is it just me? Uh-oh. All right, if that's...
I think we did.
Yes, so apologies to the audience. I think we had a little network failure there, right in the middle of her presentation. In order to keep things going, I'm just going to move to Benson in Kenya. Our trip north is moving ahead at lightning speed. Benson Yago, who is a senior official at the Competition Authority of Kenya, our enforcer on the panel. Benson, welcome. And when Chabo rejoins, I will briefly or perhaps you can advise her, since you will have the floor and the microphone, just advise Chabo that we moved on to you, and we'll get back to her, please. So I'll give you the microphone, Benson. There she is. Chabo.
Hi. Sorry,
Hi.
internet terrible.
No worries, no worries. I was going to let's. I just transition to Benson. We'll have him
Okay.
do Kenya, and then we'll move back to you. Okay.
Hopefully, I'll still be here.
Yes, Benson, go ahead. Unmute.
Am I audible now? Am I audible? It's okay.
Yes, you
Yes, the Kenyan Competition Act, the current one, came into force in 2010. That's when it was enacted. And after about 3 or 4 years in terms of the enforcement, we realized that there were a few weaknesses regarding the provisions of the law. One of the weaknesses that we realized was that the Act actually provided that the authority can impose administrative penalty, administrative financial penalty, but actually it did not actually indicate how this one can be calculated. So one of the amendments which was made actually is to provide guidance that at least the administrative financial penalty that the authority can impose will be up to 10% of the preceding year turnover. So this one has actually made it easier for us to impose penalties. And in terms of that one also, we came up with guidelines on findings. We actually stated very clearly to mitigate the factor that we consider in terms of the scoring, so that the parties are aware of what the authority takes into account when calculating the percentage that is supposed to be imposed. That has actually increased the transparency in terms of the operations of the authority. Another area actually where we decided to amend the law is with regard to the abuse of dominance provisions, where initially the law provided that remedies were supposed to be criminal, which means that they were supposed to be prosecuted in a court of law. And considering that the authority doesn't have the prosecutorial powers, we had to forward these ones to the government prosecutor, public prosecutor. We realized they were taking quite some time, and based on that, the law was amended to empower the authority to actually deal with the violations relating to unilateral conduct administratively, and also can impose a penalty up to 10% of the preceding year's turnover of the company which is involved in that. Another area which I would wish to say is that we have also actually introduced in our law abuse of abuse of buyer power. In terms of abuse of buyer power, the genesis was that big supermarkets were actually dishonoring their contractual obligations to the small sellers, the small and medium enterprise sellers. So it was a big outcry, and actually this was a policy which emanated even from the Ministry of Trade and other policymakers which are not the authority. The thinking was that the fact that most of the small-scale dealers were not actually given their money at the right time made them to be uncompetitive, and many of them actually dying. So to protect them, actually, the provisions regarding abuse of buyer power was introduced into the Competition Act. And right now, actually, it is being enforced. Another thing which actually has taken place is in terms of the cooperation. Professor Fox actually talks about the cooperation. We have been having cooperation with the COMESA Competition Commission, but initially it was basically with regard to mergers, because initially they have just been dealing with merger enforcement. This time that actually they have started enforcing actually the provisions of their law that deals with the restrictive trade practices. We have started actually also to cooperate with them in terms of the investigation of those practices. In terms of the cooperation, it is basically when a matter has got a COMESA dimension, then actually they indicate it to us, and if they want information which is actually domiciled in our country, then we facilitate getting of that information on their behalf. Bilaterally, we have not been very active, but I think we have had just very few interactions with the South African Competition Commission. There was an interrogation which was being carried out in the broadcasting sector. We were carrying it out, and at the same time they were carrying it out. So we decided to exchange notes on that matter. But we realized that as we were pursuing abuse of dominance, but with them they were pursuing possible international cartel. So we exchanged notes on that, but we have never had very serious collaboration bilaterally with other competition agencies in Africa. But it's a matter that actually we need to push forward so that we synchronize our investigations and make sure that the anti-competitive practices within Africa actually are eliminated or reduced to significant levels.
Thank you, Benson. And I think that picks up nicely on what Eleanor mentioned earlier about the cross-border nature of so many cases in our field of law, in antitrust and competition law, be it transactional mergers and acquisitions or cartels, or even abusive dominance cases. And I know what you did not touch on just now, but I know from our previous calls together preparing for this panel, you also mentioned previously that the Kenyan authority has also gotten somewhat more engaged, also under the amended act, with consumer protection issues, which clearly is of relevance now during this post-COVID, to use Professor Fox's term, during the post-COVID era. And that provides a nice transition back to Chabo Peo in Botswana, because I understand that Botswana has also enlarged its and enhanced its consumer protection provisions. But since we had that technical glitch, Chabo, let's rejoin you, remute ourselves, the others, and let's hear what you have to say regarding the developments in your country.
Thank you. Yes, you're correct. In terms of the new act, the mandate has increased, and the Competition Authority now also enforces the Consumer Protection Act. The authority has been renamed to be the Consumer and Competition Authority, the CCA. What we have seen, and similar comments raised by Benson, Eleanor, and John, is there's an increased level of protectionism that is being seen in our regulation and in decisions taken by the authority. In terms of the new act, what the new act has introduced is a new provision that allows the Minister of Trade to give input in measures where there is a public interest, a serious public interest consideration. That hasn't been defined, so there are no guidelines as to what amounts to that. And what we've seen previously is they tend to broaden that scope immensely. And in previous mergers, what's happened is you get distortions, and there isn't a clear distinction, there isn't a clear line whether or not decisions are being made purely on competition issues, or if it's now completely been removed from a competition perspective and they're doing what a different regulator ought to be doing, which is regulating citizen economic empowerment issues. So we expect to see a heightened increase of that in terms of the new act that allows the minister to directly input his own suggestions or considerations. And I expect what we'll see is what John has seen in South Africa, where parties now go directly to the minister, and instead of adjudicating conditions with the regulator, we have a situation where they come through the minister, and it distorts the role of our regulator. Additionally, new amendments that have come in, our previous act didn't have any financial or criminal sanctions. So where parties were engaged in mergers in breach of the Competition Act, the only powers the authority had were to unwind the transaction or to try and put back into place the competition conditions that were previously. So now, in terms of our current act, what the authority can do is they can impose a fine of up to 10% of either the consideration or the combined turnover of the party. So what isn't clear though, and what tends to be an issue in our jurisdiction, is whether that 10% relates to global turnover or is going to be restricted solely to income derived from Botswana. And in previous situations, we were trying to assess just even thresholds, whether or not thresholds have been met. You find yourself in debates often with the authority about where they want to broaden the scope and include the entire global turnover, where it's not really practical, and I don't think it's not what's ordinarily done, where you're able to isolate a stream. You should be able to just restrict the fine to your Botswana income. But we'll see as we progress with that, we'll see how they adopt that. So what's also been introduced is personal liability in respect of restrictive practices. Now directors and officers can be held personally liable, and it's a fine of not exceeding, I think it's about $50,000 US, and a criminal sanction, I think it's up to 5 years, imprisonment of up to 5 years. What isn't clear though is where regulations will be published, because we've got the new forms. The new forms are being published, but there's intimation that the regulations themselves will also be republished. So that's one thing we're all looking out to see. And additionally, unlike another interesting thing that I've noted is, unlike most jurisdictions post-COVID, is our authority has been very silent. So we've had situations similar to South Africa where banks, etc., are being allowed to caucus, but our authority has generally been silent in that respect. So it's unclear what role they will play in regulating that space as well. So we're just gonna play it out by ear and watch and see what they do.
Thank you, Chabo. That was a comprehensive summary of those developments. And I find it fascinating that you are introducing, or that the country has introduced, personal liability. That in our experience, and I know I was giving one of my first talks as a baby lawyer in South Africa many years ago, when South Africa was introducing criminal liability for individuals for hardcore cartel conduct. I assume that's the same in Botswana, that it is only for hardcore, so-called hardcore offenses, right?
Yes, that's correct.
Right, cartels and market allocation and the like.
Yeah.
Correct. Mike, before, since we are under time crunch to have Eleanor Fox give her thoughts before she has to go teach her class, let's move on to you now, and perhaps can you do a sort of continental spread, if you will, to keep the geography alive here, from South Africa all the way to the Horn of Africa?
Yeah, hello everyone, and thank you, Andreas. I'll try and do a continental spread in quick time. I think what I wanted to pick up on is the theme about public interest considerations being expanded beyond just merger control to other areas of enforcement. And I don't think it can be any more graphic than in South Africa's case, where the recent amendments to our abuse of dominance provisions very clearly cater now for a socioeconomic industrial policy angle. And for those who are listening and who aren't familiar with our act, essentially what the underlying hallmark of our amendments now is that there is a category of competitors framed as small, medium, or historically disadvantaged competitors who are framed as a designated class, if you like, and for which there are separate standards applicable in determining whether or not abuse of dominance conduct has been found, and there are first-time administrative penalties for that contravention. And why I raise that, I think, is not only a significant departure from sort of international norms, but it raises a number of polycentric issues and the balance between trying to arrive at sort of socioeconomic goals and pure traditional competition goals, which I think in many cases can be harmonious. If you look at, for example, the amendments to the price discrimination provisions under the South African Act, which I think is perhaps the most graphic hallmark of this, there is an prohibition on dominant firms from relying on, for example, quantity-based defenses or efficiencies, which lead to differential in pricing that impedes the ability of small HDI-owned or medium enterprises from competing in the market. Now, there are a variety of things one needs to think about here. And I think if one goes back to sort of consumer welfare standards, and if one is looking at the prism of public interest or the role of public interest or non-traditional competition factors in enforcement, to arrive at an outcome where you're facilitating entry into the market and you have a more vibrant market with smaller players participating effectively and efficiently, and that in itself poses competitive constraints on incumbents, that's a good outcome, I think, for all. Where it becomes a bit more challenging is if you look at the Competition Commission's draft guidelines, for example, and I emphasize they are still in draft form, where the guidelines expressly preclude considerations of consumer welfare standards or the level of efficiencies of, let's say, a downstream purchaser in the context of price discrimination. And that potentially leads to a number of unintended consequences, which I don't know if they've been fully thought out. And perhaps more problematically, I'm not sure whether the four corners of the law permit the adjudicative authorities the necessary flexibility to balance the public interest assessment with pure traditional competition standards, unlike the merger control regime, where there's the very express mandate to balance the interests of the two and hopefully come to some sensible outcome. I fear that the express wording of the legislation is so that is a material risk of having dampening very pro-competitive conduct, pricing discrimination strategies, which are common in everyday practice, which by and large is pro-competitive and pro-consumer. And by hindering a very pro-competitive, ordinary pro-competitive conduct, you have the unintended consequence of dampening the very type of competition we actually want in our market, which serves consumers. So I think that is currently in the South African context, from an abuse of dominance perspective, a key area. Those principles or this notion of protecting or trying to facilitate entry of small, medium, and historically disadvantaged persons to the market find themselves into the excessive pricing prohibitions. And we've also introduced a buyer power provisions, which I think to some extent follows the lead from Kenya. I think Kenya had introduced express buyer power provisions before the South African authorities did. Again, and that also I think ties in with what Chabo mentioned. The buyer power provisions are not linked to a pure competition test, but have a more consumer-centric orientated element to it. Sticking very briefly, I think, and I know we're running out a bit of time, sticking very briefly with the abuse of dominance theme, I think what we have seen is going north of our borders to the region, looking at COMESA, we have seen more activity from COMESA in looking or assessing vertical restraints by dominant firms. It's usually been by way of exemptions or prior notifications. They have looked at minimum resale price maintenance issues, for example. And I think the unfortunate reality with COMESA is that we just don't get very detailed or robust decisions from the agencies, whether the outcome is a correct one or not. We just don't get sufficiently robust decisions to really draw meaningful conclusions from the way they assess it. So let me pause there for now, and I think we can get back to some of the other topics later on in the discussion.
Thank you, Mike. And I want to move quickly to Professor Fox, to Eleanor, because again, she has her class. By the way, your last point there does raise an issue that we mention often on the blog, africanantitrust.com, which I want to highlight for every attendee here. It's a good resource for information about this topic, competition law in Africa, that decisions of various agencies must be and really should be detailed and give robust grounds for the ultimate outcome, whether it is to approve a merger or to fine a company for abuse of dominance. Professor Fox, I will give you the floor. You have carte blanche, but before I do, there's a question for you, and it's actually a good one that I would not mind you addressing if you could. And it's interestingly from an anonymous attendee. I did not know that we could do that. I thought Zoom was identifying everyone. But the anonymous attendee says to Professor Fox, taking into consideration that markets in Africa differ and the goals of competition law differ, I don't know about that one, but okay, do you think that there are times when nationalism can be justified? I think I know your answer, but I let you tell us what you think.
Oh, so that's a great question. And thank you very much for the question. And also all of you who have made remarks today, Chabo, Benson, everyone, I really enjoyed them. I think they helped the project. So what I want to say actually fits in with that question. Markets in in Africa are generally different from the developed world. They're less fluid. There are many more restraints and barriers. In addition, in my view, goals do differ. And they partly differ because of the situation. You might say that the developed countries have put the developing countries in the whole past history of colonialism, plus the fact that the big powers in the world always have a greater say on how to solve economic problems, and the vulnerable countries always have the brunt of it. So, and goals, I think it's perfectly correct that the African countries consider the equality goal. I think there's no way to escape it. I think it's also perfectly correct for the developing countries to have recognized that antitrust in the developed world has gotten over technicalized, making it much harder for countries that are much poorer and have fewer resources to apply their law. So there is, as some of you mentioned, and Mike was mentioning in part of his remarks, there's an area in which the equity interests and the efficiency interests actually coincide. And this is the area where it takes a little more in the developing countries to knock down the barriers, that there are more barriers to entry and to succeed in the markets than there are in the developed countries. And it's really hard to knock them down when you have fewer resources. And this is an area which would be access, entry, more equality of opportunity to contest markets. And there's a very sort of waiting field for principles rather than just rules and preferences to be developed that would make the law coherent, and talking about what is anti-competitive, what you need to make markets more competitive, and to help the entry of the left out majorities of people. So I see that as a good area for attention and improvement. I also think I agree with what Mike said about one shouldn't block out the stories of efficiency, that you want to help the people. You're not trying to help the incumbents, except you want foreign investment, of course, you want a good, healthy economy, but you're trying to help the people, and doing that, you want more fluidity of entry. So is nationalism ever justified? I think that if you call helping your own small and middle-sized enterprises enter the market, you could call that nationalism. You could do it by way of quotas, which is the worst way. It's very important for the African countries to think hard about this problem of equities right there on the table. It's very important. And how to do the equity in a way that's market friendly. Sometimes you could call it nationalism. I think it doesn't even rise to the terrible nationalism that my own country is doing right now, and some other countries are doing right now. And my initial remarks were really about how the developed world is applying nationalism in a way that really sets back developing countries. Now I really have to get off and teach my class, but thank you for the opportunity to participate.
Thank you, Eleanor. Invaluable contribution, both to our panelists and to the audience. Thank you.
Great, thanks.
As we bid farewell to Professor Fox, I would like to ask one more question that was proposed by Grace Nsomba, and that is an audience member, and that is, in short, in light of the pandemic, the COVID-19 pandemic, can we reasonably expect the competition authorities across the continent to deal more with consumer protection issues as opposed to pure competition law issues? And Eleanor Fox touched a little bit on that indirectly by speaking about the highly technicalized antitrust and competition law enforcement that we see in the West, and how that really does not necessarily always fit with enforcement and enforcement agencies across Africa. Perhaps very briefly, Benson, since we have the honor of having you on this call as an enforcer, can you touch on that? Do you think that your authority, the Kenyan authority, will become more active for at least a few months, if not longer, in the consumer protection arena?
Well, thanks for that question. Well, from the time actually this pandemic came in, we have realized a significant drop in the traditional antitrust matters or competition matters. One of the reasons is that there are a lot of limitations in terms of movement. So very few people actually go to the offices. So I think from that time, we have not been able to get complaints on competition matters. In terms of mergers, it has drastically dropped. I think it is very, very few merger cases that we are handling as at now. I think because the company is going to make sales, even the potential investors are actually still guessing what is likely to happen. So in terms of mergers, it has really led to a serious reduction in terms of the workload. But in terms of consumer protection, it has really gone so high. And one of them is because some of the essential products or commodities, the prices actually went high because these suppliers took advantage of the situation. Some of the critical ones were the masks. When the government declared that masks are essential, sanitizers, among others, the suppliers of those products actually increased the prices by a big margin. So what the authority did is that we were getting a lot of complaints through our complaints box. What we did was that after we wrote to these companies and we required them to provide us with the information regarding the prices before and the current prices. One of them, actually some of them, the authority directed that they refund the purchasers of the sanitizers the overcharge, because before the announcement, they were selling at 800 Kenya shillings. Immediately it was announced, it went to 1,000 Kenya shillings and above. So within a few hours, it was the price went so high. So what the authority did was just to require them to actually find out all those people who purchased the sanitizers from them and make sure that they are refunding the difference. Actually, what they did, they actually advertised through their online platforms and even one of the daily newspapers that those people who bought the sanitizers from them above the 800 shillings were supposed to go to their offices to get a refund. We have actually been following these ones. In our institutions, we have what's called the compliance. Once we make a decision, we always go to find out whether actually there's compliance. The problem that these people are having in terms of this one is that they don't keep records of all the people who actually purchase from them. So if you don't turn up to go and claim with the receipt, then it's difficult for them to refund you. Right. So that's another problem that we have already found there. But they made an effort because actually they purchased a space in the newspaper and advertised and invited those people who were overcharged to go and claim for the overcharge. So basically, it has given a lot of work. Thanks.
Thank you. In brief, I think what you're saying is there's definitely a shift of resources in your agency from traditional antitrust enforcement to consumer protection, to answer the question. Very briefly now, and we try to keep it really to the hour and be good about this. Mike, can you give us a 2-minute wrap up, and then I will ask Chabo, to the extent that she has any other comments based on what was said, and John to conclude today's panel.
Sure. So the overlap between the competition and consumer enforcement is, I think, quite apropos in relation to South Africa as well, because since the pandemic was declared a national disaster, the Competition Tribunal in South Africa has a dual role to assess any pricing issues, as Benson sort of articulated, which is prevalent here as well, both under Section 8.1, our traditional excessive pricing provisions, as well as our Consumer Protection Act, which historically was assessed by different authorities, which talks about unfair and unreasonable prices. And yesterday, by way of a settlement agreement, it was the first case that the tribunal actually ruled on a case where, in that case, it was a pharmacy who increased face masks and hand sanitizer prices excessively. Didn't impose a penalty, but did require of that pharmacy to donate various products to old age homes and charitable institutions. So there's a whole expedited review for that. The tribunal is dealing with those matters on an urgent basis, and I think it's been very, very proactive in dealing with the same issues that Benson highlighted.
Thank you, Mike. Chabo, there are two questions pending, and I think one is more for South Africa, so I will reserve that to John later. But the other one, perhaps you can address, which is from Vela Kigwiru, I assume from Kenya. So perhaps Benson can just nod his head or shake his head, depending on what you think about this, Chabo. But I do want to get your take on this. Fundamentally, the question relates to communicating with the agencies these days. And I know you're an active practitioner in this area. Virtual communications, such as our panel today, as opposed to being in person at the ABA spring meeting, which would be taking place right now in Washington, D.C., which was canceled. Virtual communications are, of course, the way to go. And the question here is it safe and is it feasible to communicate with the various enforcers via electronic means, especially in light of the fact that there are often confidential pieces of information? So I'll tell you my perspective. I think the answer is fundamentally yes, but I want to hear your take on this.
Yes, fundamentally yes. The authority has designated specific offices that are available for you to communicate with electronically. However, they have published that all their services are currently suspended. So we don't have the option of e-filing of any form currently. So all reviews have stopped, all submissions have stopped. I don't know what will happen if the lockdown period is increased. I suspect they will set up some kind of e-filing service, as other government agencies have done. So at the moment, the communication would just be on an administrative aspect and not actually to progress any transaction. They aren't progressing any transactions currently.
Thank you, Chabo. And I sort of see Benson nodding his head and agreeing with respect to Kenya as well. You guys have active email communications, etc. Thank you. In the interest of time, John, and you see the question there that is from the anonymous attendee regarding public interest. This may very well sort of jive with your concluding remarks anyway. So I won't repeat the question here, and it's from an anonymous attendee. So I can't identify that person. But why don't we conclude the panel with you, John, and your parting thoughts?
Sure. I mean, I think it's obviously a very good question and one which I tried to address. I think the difficulty in relation to ensuring a complete and active tribunal role in relation to the adjudication of mergers where public interest issues are going to be front and center, and particularly ones advocated from the ministry, is if the parties agree to some form of conditional approval in advance, and those are ultimately then made a condition by the tribunal in terms of the processes which the tribunal handles. Unless the parties are willing to have these openly advocated and engaged upon or assessed before the tribunal, that process can't necessarily be avoided. And I don't think it's a tribunal issue. I think the difficulty comes in, and perhaps where I suppose my thrust has come, is where what parties are ultimately faced with, and where I suppose the difficulty comes in even from a practitioner perspective in relation to advising on cross-border transactions, is if the ministry decides to become robustly involved and there is at least an opportunity to assuage those concerns, the large threat of the ability of the ministry to intervene. I mentioned what the amendments permit, and I mentioned the robust intervention which had occurred in the past, pretty much put parties on the back foot to try and at least engage directly with the ministry and agree to those conditions. And what that does mean is it pulls the rug from beneath the tribunal, because those won't be openly engaged upon, or at least brought to the fore and litigated upon. And that's a major risk. And until, I suppose, this robust interventionist strategy or stratagem and permissive stratagem is curtailed or legislatively curtailed or discussed again in forums like this, or the ICN or the OECD or other agencies or other bodies, unfortunately, that's going to be a reality, is that parties will take the quick route. They will seek to try and resolve this, and you cannot blame parties, given the current predicament of trying to conclude deals as expeditiously as possible, avoid significant costs, and try and eke out some certainty. Again, litigation is always an uncertain process. So unfortunately, I don't think that there is, unless the law changes, a clear way of ensuring that there's going to be a dedicated, openly robust assessment of each public interest element driven by the ministry before the tribunal.
Thank you, John. And I think that last point that you raise, speaking of unless there's a change in the law, also dovetails with the very last question that we have. And I must say, I'm very happy and proud that we are able to keep this to precisely our appointed time of an hour and we covered all the questions. And let me just cover the very last one, which I see here from, I think it's Betty Mkachwa, regarding post-economic recovery. Are the current antitrust laws practical for economic recovery, or will there be a necessity of having sort of temporary relief amendments? And I think just to put a bow on it and conclude, I'll give my brief opinion as moderator. I think, of course, there are currently in virtually every jurisdiction emergency measures being taken. We had a panel last week, another Primerio sponsored webinar, where we had the comments from South Africa, where the agency does allow, just as in Europe and in the US, certain collaborations between healthcare suppliers, for instance, so that they can better assess where things like masks and PPE is needed. So there are these temporary relief measures legislatively. However, I think regarding rebuilding the economy, it is very, very dangerous and a slippery slope, as we like to call it, to encourage further cooperation, which can easily lead to cartel behavior. So to relax antitrust laws only in the interest of, quote, rebuilding the economy, I think would be a dangerous precedent. Betty, that relates to your question. So thank you to all our panelists. We really appreciate it. And we hope that the audience found this interesting. We will have more. Check on the Primerio website and check on the africanantitrust.com blog. Both good resources. And of course, again, a virtual clap and thank you to Benson, to Chabo, to Mike, John, and of course to Professor Fox. Thanks everyone. And this will be recorded, or is being recorded, and will be made available as audio and video, I believe, as well on the Primerio.international website next week.
Goodbye. Thank you.